Of Alexander Lewis-Ranwell against G4S Health Limited and others.
Yes, Mr. Moon.
Lords and ladies, I appear on behalf of the first appellant, G4S, together with Mr. Gurian Tosig. To my left, for the second appellant, the Trust. Thank you. Ms. Judith Ayling, King's Counsel, together with Alex Ruck-Keane, Honorary King's Counsel, and James Goodcamp. The latter two, I think, are in the row behind us. Yep. For the third appellant, the Counsel, Andrew Warnock, King's Counsel, appears together with Jack Harding. And for the Respondent, the claimant, Selina Plowden, King's Counsel, appears together with Christopher Johnson and Rachel Woodward. The issue before the court is whether the heads of loss claimed in the tort of negligence are barred by the doctrine of illegality in circumstances in which the respondent killed 3 people, was found not guilty of murder on the grounds of insanity, and now seeks to recover damages for his detention and the other consequences of the killings. And the appellants say those heads of loss are barred. In terms of timing, the intention is that the appellants will make their submissions today, and then the respondent will make his submissions tomorrow, with, we've agreed, 30 minutes for a reply at the end of tomorrow. The appellants have discussed how to avoid repetition, because as you will have noticed, in the cases on behalf of the appellants, there is inevitably a good deal of repetition. We believe we are going to be able to avoid repetition. There may be some. We propose that I will, of course, go first, then Ms. Ayling, then Mr. Warnock. It may be I go slightly over my time allotment, self-allotted time of an hour and a half, but my learned friends are content with that.
Well, I'll leave it, I think, to you, Ms. Ayling, and Mr. Warnock to police your own timing.
Yes.
Subject to the overall limit.
Yes. I'm sure there will be a scoop to do that. We, that is to say the first appellant, G4S, propose to address the court under 3 main headings. First, is the Supreme Court decision in Patel and Mirza the controlling authority? Second, if so, what is the outcome of applying the Patel and Mirza approach? And thirdly, we will address the reasoning of the Court of Appeal. So going straight to the first question, is Patel the controlling authority? And there is a stark difference between the appellants and the respondent on this. The appellants say that Patel is the controlling authority. The respondent says that because he was not culpable and that no prohibition was transgressed, Patel is simply not engaged at all. We don't get to Patel. We submit that Patel is engaged, is the controlling authority for 3 main reasons. Firstly, there is no binding authority on the application of the illegality doctrine in a case in which the claimant was found not guilty of murder by reason of insanity. And we submit that in Patel, the court was concerned to develop an approach which would assist in precisely this sort of situation, when the issue of illegality arises, but earlier authority does not supply a clear answer to the applicability of that doctrine. Reflecting what Lord Hamblin said in Henderson, a case to which I'm going to turn, but of course there are 3 members of this panel who were on the panel in Henderson, but reflecting what Lord Hamblin said, Patel does not represent year 0 for illegality cases, but pre-Patel cases are only binding to the extent that they address the particular factual situation before the court. That is paragraph 77 of Henderson. And none of the earlier domestic cases concern a case in which the claimant had been found not guilty of murder by reason of insanity. Secondly, as to why Patel is the controlling authority, even if there had been binding authority, which we say there isn't, but even if there had been, the Supreme Court made clear in that same paragraph in Henderson, paragraph 77, that it would still be necessary to circle back to Patel to check whether that earlier authority is compatible with the approach in Patel. Thirdly, the pre-Patel authorities we submit on whether there is a need for knowledge of wrongdoing in order to establish illegality are not clear. We're going to show the court two cases on this point, one older from 1933 and one more recent from 2013. Can we make the first appellant's case on this clear? Because the respondent says there's a difference between the appellants on this question of the extent to which wrongdoing is important. We accept that in order to engage Patel and the illegality doctrine, there must be some illegality, that is to say, some transgression of a legal prohibition. And in that sense, and on reflection when I reread our case, I thought we did not make this clear. In that sense, there must be turpitude. So we align ourselves with what Ms. Ayling for the second appellant is, I anticipate, going to say about this. But, and this is where we part company significantly with the respondent, we submit that illegality does not have to involve the commission of a criminal offence. Now, just to place the parties on the spectrum of where they are on this issue, we understand the respondent to submit that the defence of illegality is simply not engaged unless there is culpability. And we submit that the conduct does not have to be culpable in the sense of knowing wrongdoing in order to engage the illegality defence. But that is not to say that the extent to which the conduct is culpable is irrelevant. We're not saying it's irrelevant. We say it is more relevant when one gets to the stage of proportionality in the Patel trio of considerations. So, my lords, my ladies, I turn to the two pre-Patel cases which I'm going to refer to. And I hope to navigate through an electronic bundle using the page numbers of the bundle in the electronic version.
Yes, that would be very helpful because we don't have hard copy bundles.
No.
Other than the one that has the parties' arguments and the judgments below.
I won't be referring to that very much, so I will be referring to the electronic bundle. The parties have identified page numbers not just by reference to page numbers, but also by reference to sections and tab numbers. I must confess I didn't find that particularly helpful, so I'm not going to refer, that's no criticism of anybody, but I'm not going to refer to the tab or section numbers, just to the page number.
Well, as long as your colleagues on the bar can cope with that,
yes.
That's not a difficulty for us.
I very much hope that if somebody can't cope, they will flag it up.
I don't see many paper bundles.
No. So, my lords, my ladies, if one turns to page 1627, 1627, where the report in the case of Hazeldine and Hoskin, reported in the King's Bench reports for 1933, at page 822 appears, I hope. This is a decision of the Court of Appeal in which a solicitor had suffered loss, and I'm really taking this from the head note for the moment, as a result of entering into a champertus agreement. And he made a claim under an insurance policy for that loss, but his claim was defeated by illegality, champerty being a crime at that time. The judge found that the solicitor was unaware that the agreement was forbidden. But the Court of Appeal held that notwithstanding that lack of awareness, it was contrary to public policy to permit the solicitor to recover. And I'm going to skip, if I may, the judgment of the judge at first instance and go to Lord Justice Scrutton's judgment, which I hope is to be found at page 1634. And again, rather than referring to the law review, I'm going to be referring consistently to the electronic page numbers. Lord Justice Scrutton's judgment begins there, but the pertinent passage begins at the bottom of page 1637. That is to say, 832 of the reports. 1637, and I'm reading from 6 lines up from the bottom, halfway along the line, 1637. It is quite true that he, that's the solicitor, appears to have been unaware that what he was doing was illegal or that he was committing a criminal offence. That, however, is not the kind of neglect, omission or error contemplated by the policy. I approach the consideration of the policy in 2 ways. If making a champertus agreement is a neglect, omission or error, it's contrary to public policy to insure against it. It is clearly contrary to public policy to insure against the commission of an act, knowing what act is being committed, which is a crime, although the person committing it may not at the time know it to be so. And to like effect is the judgment of Lord Justice Greer at page 1641, halfway down the page. In the 4th line, Lord Justice Greer said, "I accept, as we must, the learned judge's finding that the solicitor honestly stated that he did not know that the agreements he made with his client were illegal." Now, it is right to say that this case was not referred to by the Court of Appeal in their judgment. And as I understand it, though no doubt I can be corrected if I'm wrong by those who appeared in the Court of Appeal, I did not, it was not cited to the Court of Appeal. But it is an important case in this sense because we submit that the issue of awareness of wrongdoing and the extent to which that mattered under the doctrine of illegality was one of the barnacles which had encrusted the common law so that it had become an incoherent mass of inconsistent authorities prior to Patel. And that colourful language is not all mine. That comes from Lord Sumption at paragraph 61 in Bilter, and which for your, I'm not going to take the court to it, but for your reference is at page 1244, letter G. And the Law Commission also, the Law Commission's report on illegality also touched on this point. And this is in our bundles at 4520, page 4250, where we see 4520. 4,520, yes. This is the 2010 Law Commission's report on illegality. And if your lordships, my ladies, look at paragraph 1(3) at the bottom of that page, yet illegality may affect a civil claim in numerous ways. The illegality may be deliberate and serious, or it may be accidental and technical, it may be inextricably linked or fairly incidental. The parties may be equally guilty, or one may be more responsible than the other. To date, the common law rules have found it difficult to cope with such a variety of circumstances. So, if I could then turn to how the question of culpability has been addressed in more modern authorities, indeed after the Law Commission's report, and turn to the case of Appellants, which begins, so far as the Court of Appeal's judgment is concerned, at page 1849. This case was, of course, not about the commission of a crime, but about infringement of patents. And the facts, as my Lord Hodge has written, are somewhat complicated, but for the purpose of my submissions, that doesn't matter. We would like to show the Court the judgment of Lord Justice Etherton, which begins at 1852. 1852. And it has been said, and one can find it in the judgment, that Lord Justice Etherton espoused in this Court of Appeal judgment a philosophy of illegality which foreshadowed the Patel approach, the approach that came to the fore in Patel. But for the purposes of the discussion about culpability, I would ask the Court to go to page 1861, 1861. At letter H, above letter H, paragraph 42, there, Lord Justice Etherton records the submissions on the illegality principle by counsel for Appellants, Mr. Toledano, who had conducted a review of a large number of cases, including some of the cases referred to by the Court of Appeal in the instant litigation. And at letter H, he summarized the principal line of argument on behalf of Appellants. A claimant will only be denied relief by applying the illegality principle if it can be shown that there was culpability on the claimant's part. That element of culpability is not satisfied unless either the wrongdoing is manifest, such as murder, or the claimant had knowledge of all the ingredients of wrongdoing at the time it committed the acts in question. In the context of a tort of strict liability, such as patent infringement, it isn't enough that the claimant intended to carry out the act which gave rise to liability on its part. It must have intended to infringe what it knew to be a valid patent. And we can see how Lord Justice Etherton dealt with that submission in the Court of Appeal's judgment at 1869, 1869. And in essence, he rejected the idea that culpability is the touchstone. At paragraph 76, on the other hand, I also reject the bold proposition advanced by those of the counsel for Appellants, that where the illegality is the infringement of a patent, the illegality defence can never apply unless the claimant was aware of the patent, knew it was valid, and intended to infringe it. It all depends on the precise circumstances. Now, of course, that case went to the Supreme Court, and this court gave a majority judgment, and in the majority on this occasion was Lord Sumption. And the judgment of the Supreme Court begins at 1875. We have made the point in our case that the majority decision in Appellants in the Supreme Court, reflected in the judgment of Lord Sumption, was underpinned by an approach to illegality which was later to fall out of favour in Patel. But of course, we must consider Lord Sumption's judgment. On one view, the ratio of this case is that the public interest is not engaged in the tort, strict liability tort, of infringement of patent. And on one view, I put it in that way because it's plainly arguable, on one view, what Lord Sumption said about illegality and culpability is not part of the ratio. And since Lord Sumption was, if I can put it this way, I hope neutrally, on the losing side in the Patel argument, one must view his judgment in Appellants with some degree of caution. But that said, if one goes to page 1890, at letter C, Lord Sumption asked the question, what is turpitude? And the paradigm case of an illegal act engaging the defence is a criminal offence, so much so that much modern judicial analysis deals with the question as if nothing else was relevant. Yet in his famous statement of principle in Holman and Johnson, Lord Mansfield spoke not only of criminal acts, but of immoral or illegal ones. What did he mean by this? I think that what he meant is clear from the characteristics of the rule as he described it, and as judges have always applied it. He meant acts which engage the interests of the state, or as we would put it today, the public interest. The illegality defence, where it arises in the public interest, irrespective of the interests or rights of the parties. And Lord Sumption expanded on that in paragraph 25 at page 1891. I'm just going to read, if I may, the first 6 lines. The ex turpi causa principle is concerned with claims founded on acts which are contrary to the public law of the state and engage the public interest. The paradigm case is, as I have said, a criminal act. In addition, it is concerned with a limited category of acts which, while not necessarily criminal, can conveniently be described as quasi-criminal because they engage the public interest in the same way. And then in the rest of the paragraph, Lord Sumption gives examples of cases which have engaged the public interest in that way. We would submit a non-exhaustive list. We submit that because he talks about the examples including cases of dishonesty or corruption. Now, getting to the point, the order authorising this respondent's detention subject to special restrictions under sections 37 and 41 of the Mental Health Act in this case, following the special verdict found at the criminal trial under the 1964 Act, the Criminal Procedure Insanity Act, plainly engaged the public interest. That was not simply an order made in private law proceedings, but involved a decision by the state to detain the defendant in the interests of the public and in order to protect the public. It is part of that part of the law which is not at the free disposition of private individuals. That latter phrase is taken from Lord Sumption's judgment in Bilter at paragraph 100, which is at page 1262F. It has been the function of the legislation relating to insanity since at least before 1800 to protect the public. That is what Lord Diplock said was the purpose of the legislation in the Sullivan case in 1984, The reference there is page 2512F. A disposal under sections 37 and 41 of the Mental Health Act also engages the interests of the state and the public interest. In this way, the interests of the public safety after a Section 41 restriction order is made are transferred from the responsible clinician to the Secretary of State for Health. Sorry, it's the Secretary of State. I'm not sure it is the Secretary of State for Health, but it's the Secretary of State. And what is now the first-tier tribunal, mental health. I tried to use the up-to-date terminology there. If you look at Henderson, if the court looks at Henderson at paragraph 27, the references are to the, I think, Mental Health Review Tribunal. That has become the first-tier tribunal, mental health. So we submit that even if Lord Sumption's taxonomy is part of the ratio and survives Patel, the respondent's acts in killing whilst insane were quasi-criminal in the sense described by Lord Sumption because they engaged the public interest irrespective of the rights and interests of the parties to this litigation. Allied to that, we also submit that the contentions in the respondent's case, that the respondent's acts in killing did not involve transgression of any prohibition and were not unlawful, depart from reality. It is said by the respondent that there is no general prohibition on killing. We respectfully suggest that is a remarkable submission, unsupported by authority or indeed common sense. So far as authority is concerned, Article 2 of the European Convention on Human Rights, incorporated, of course, here by the Human Rights Act, begins with the words, "Everyone's right to life shall be protected by law." In our submission, that constitutes a specific prohibition on killing. Secondly, the killings were not lawful killings, but were unlawful. And the authority for that, if authority is needed, are two cases to which I'm going to take the court. One from Australia, one from Canada. One from Australia is Hunter, and the one from Canada is Barker. Thirdly, the killings were unlawful because they were actionable assaults, or more accurately, batteries, for which the respondent is liable. Before we leave the question of is Patel engaged, it may be worthwhile briefly to turn to Patel, and I'm going to take the court, if I may, straight into the judgment of Lord Toulson.
Could I just ask, Mr. Moon, you say
Yes.
it's unlawful because it's battery for which
the respondent is liable.
That's liability in tort.
It is. But that means it was an unlawful act. That's the point I'm making. When it suggested it wasn't unlawful, that no prohibition was transgressed, I make those three submissions. I accept, of course, that the point that my Lord Lloyd Jones is making, that is in tort, but that renders the acts unlawful in tort. And I'm responding to the submission, that there was no prohibition transgressed. That's the point I'm trying to make. My Lord, can I turn to Patel, or would your Lordship want me to address that further?
Thank you.
Patel, I've taken the liberty of assuming a good deal of familiarity with Patel. If your Lordships and my ladies go to page 2280, this is one of the two central paragraphs, perhaps, in Lord Toulson's judgment, where he deals with then Professor Burroughs' observation at paragraph 101, and then he asks the question, so how is the court to determine the matter if not by some mechanistic process? In answer to that question, I would say that one cannot judge whether allowing a claim which is in some way tainted by illegality would be contrary to the public interest, because it would be harmful to the integrity of the legal system, without A, considering the underlying purpose of the prohibition which has been transgressed, and then he deals with stages B and C. And then at page 2285, paragraph 120, the other paragraph that is often referred to in the context of summarizing what Patel decides, under the heading Summary of Disposal, the essential 2285, the essential rationale of the illegality doctrine is that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system or possibly certain aspects of public morality, the boundaries of which have never been made entirely clear and which do not arise for consideration in this case. Now, what we submit is that the references in those two paragraphs suggest that the illegality doctrine espoused by Lord Toulson in Patel travels far outside conduct which has led to the conviction of a criminal offence. And we also submit that those references do not suggest that when one thinks about illegality, one can only do so if the acts of the claimant are culpable. Indeed, in his minority judgment in Patel, Lord Sumption attacked the range of factors approach. And at page 2325, we can see the basis for that attack. 2325, page 262. Sorry, paragraph 262, not page. Towards the bottom of the page between G and H. Lord Sumption said, the reason why the application of the range of factors test on a case-by-case basis is unprincipled is that it loses sight of the reason why legal rights can ever be defeated on account of their illegal factual basis. It is, I think, right to make 4 points. And I would ask the court to look at the third point, or a part of the third point, which begins just above letter D on page 2326. And these are the points that Lord Sumption marshals against the range of factors approach. And if one looks just beneath letter F, 6 lines up from the bottom of that paragraph, if the application of the illegality principle is to depend on the court's view of how illegal the illegality was, or how much it matters, there would appear to be no principle whatever to guide the evaluation other than the judge's gut instinct. This was why this court recently rejected the view expressed by the Court of Appeal in Appellants that an illegal act might nevertheless found a cause of action if it was not as wicked as all that. Now, whilst we don't submit that Lord Sumption was respectfully right about all of that analysis, we do submit that it shows that on the Patel approach, one does not simply look at culpability. One does not simply look at whether there is a criminal offence that has been committed. Patel is much more nuanced than that. One last passage from Patel. We weren't planning to return to it. And it does involve going back in the bundle, and I apologise for that, to page 2300. And this is in the essentially concurring judgment of Lord Neuberger. There are slight differences between his approach and Lord Toulson's, but they don't matter for the purpose of my submission, and essentially he concurred with Lord Toulson. And he made three concluding points at paragraph 183. First, quite apart from being persuaded by the reasons which justify the approach I've summarised, I consider that the fact that it is consistent with the judgments of the courts in Australia and Canada, as explained by Lord Toulson, is a good reason for adopting the approach. When considering how to characterise or whether to develop any fundamental principle of the common law, it is normally sensible for a judge to consider how the principle has been approached in other common law jurisdictions, and it is desirable, if not always achievable, that all common law jurisdictions adopt the same approach. And we are going to be showing the court those two cases of Hunter, as it happens in Australia, and Barker, as it happens in Canada, where we say the court took the approach which we would respectfully encourage this court to take. So, on the assumption that the court finds that one does need to look at Patel and the Patel approach, can I turn to the second heading, which is the application of the Patel trio of considerations in this case. And the first stage is essentially to look at the considerations in favour of the application of the doctrine.
Making the point that Lord Neuberger was essentially concurring, I think, is paragraph 186 from 2301. His final point.
That is a far better reference than my submission. Thank you, my Lord, indeed. I had taken it, I think, from the headnote. But indeed, he specifically said that there's no significant difference. I think the difference...
Well, it's the next line. I agree with this framework for arriving at an outcome.
Yes. 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 My Lord, may I turn to the application of the Patel test, the Patel approach. The first stage to identify the considerations in favour of the application of the doctrine of illegality. And although Lord Toulson had talked about the underlying purpose of the prohibition which had been transgressed, Lord Hamblin made clear in Henderson that a wide approach should be taken, considering not just the specific purpose of the prohibition transgressed, but also the other general public policy considerations underpinning the application of the illegality doctrine. And in particular, Lord Hamblin referred to two principles, the consistency principle and the public confidence principle. That is at paragraph 119 of Henderson, at page 1745. My Lord, my ladies, as three members of this court were, as I submitted in Henderson, I wasn't going to take the court to all the relevant paragraphs in Henderson, but of course I will if required. I was going to pick up the main ones. So what we propose to do under this rubric, this part of the rubric, is to trace the development of those two principles, that is to say the consistency principle and the public confidence principle, by reference to three domestic cases and three cases from other common law jurisdictions. And all of those cases touch upon, and in at least two cases, the ones from Australia and Canada, decide what to do about a case in which a person is found not guilty of murder by reason of insanity. And we're going to look, I hope, relatively briefly by reference to the cases, at how the principles have been developed in a way that applies here. And I'll be making submissions in the course of taking the court to those 6 cases. Starting with Clunis. Clunis is to be found at page 1345. A case from 1997, reported in 1998. I think it's Queen's Bench reports, page 978. Of course, we can see from the headnote, all 3 of the domestic cases involved plaintiffs who had pleaded not guilty to murder and instead pleaded guilty to manslaughter by reason of diminished responsibility. None of those cases involved a person who had pleaded, or been found rather, not guilty by reason of insanity. So we can see that from the headnote. But I was going to show the court, first of all, the submissions made on behalf of the health authority. At 1348, we can see at letter G, G to H, just above letter G, the plaintiff's plea of guilty to manslaughter by reason of diminished responsibility means that while his mental responsibility for the crime was substantially impaired, it wasn't absent. He had mens rea. And there's a reference there to the Homicide Act of 1957, reflecting the policy of Parliament, that those who kill, knowing the nature and quality of their act, and therefore not falling within the definition of insanity, should not be excused simply because their mental responsibility is substantially impaired by reason of mental illness. The plaintiff's act was a deliberate, conscious and intentional act, and therefore he can't recover. That was the first element of the submission, but the second element is in our submission important, and that is to be found over the page, just beneath letter A. The public need for the maintenance of the integrity and consistency of the legal system requires that the claim be struck out. A line of cases based on policy indicates that the civil courts will not allow punishment, at least for an offence involving mens rea, to be defeated or evaded by allowing the culprit to recover as damages the penalty imposed by the criminal court. And we could see from the judgment of Lord Justice Belden, which begins at page 1350, that the court adopted the first submission, but did not refer in terms to the second. And if one looks at page 1357 in the judgment of Lord Justice Belden, just above letter E, in the present case, we consider the defendant has made out its plea that the plaintiff's claim is essentially based on his illegal act of manslaughter. He must be taken to have known what he was doing and that it was wrong, notwithstanding the degree of culpability was reduced by reason of mental disorder. The court ought not to allow itself to be made an instrument to enforce obligations alleged to arise out of the plaintiff's own criminal act. And we would therefore allow the appeal on that ground. So that, in our submission, reflected the first of those 2 submissions. It does not reflect what later became the consistency principle. Now, of course, we must accept, that the consistency principle, as adumbrated in Clunis, referred to punishment for criminal offences. It's plain that that's what it says, and that was what the submission was. But as we will submit, in later cases, the narrow rule has been much more widely interpreted. Just as an aside, but it may be an aside of some importance, the Law Commission in the consultation paper on illegality and tort appears to have preferred the consistency principle as a justification for Clunis in favour of the basis on which the Court of Appeal decided the case. The reference there is paragraph 4, full stop 73, at page 4700. Again, I'm not going to take the court to that. Can I turn to the second case, which is Gray? Gray is in our bundles at page 1512. And this is one of those reports that is a composite of the Court of Appeals and the House of Lords judgments, and so it's rather long in the bundle. But again, one can see from the third line that involved consideration of someone who had pleaded guilty to manslaughter around a diminished responsibility. But in this case, more so than in Clunas, there was specific consideration of what the position might be in the case of a person found not guilty by reason of insanity. If I could first take, my lords, my ladies, to the judgment of Lord Hoffman at page 1543, paragraph 29. In the fourth line, talking about the appellants' arguments, Lord Hoffman said their principal argument invokes a special rule of public policy. In its wider form, it is that you cannot recover compensation for loss you've suffered in consequence of your own criminal act. In its narrower and more specific form, it is that you cannot recover for damage which flows from loss of liberty, a fine or other punishment lawfully imposed upon you in consequence of your own unlawful act. In such a case, it is the law which, as a matter of penal policy, causes the damage, and it would be inconsistent for the law to require you to be compensated for the damage. Again, he, certainly in relation to the wider rule, refers to a criminal act. It may be that there was the beginnings of a change in relation to the narrow rule, because Lord Hoffman didn't refer to a criminal act when he was referring to the second part, the narrow rule, but to an unlawful act. That may be reading too much into it, and there are much better authorities which I'll come to which make the point. Just a couple more paragraphs from Lord Hoffman's judgment, speech. If one goes to page 1547, and here at paragraph 42, Lord Hoffman referred to the Hunter case in Australia. And Hunter was a case which dealt with, as part of the ratio, the question of what to do about somebody who was found not guilty of murder by reason of a mental illness. I put it in that way because the Australian approach is not to use the old-fashioned word insanity, but it's the same thing in the sense that it's not guilty by reason of a mental health issue. And in Hunter, as we see from paragraph 42, the plaintiff who'd been negligently discharged from a psychiatric hospital was acquitted of murdering a woman on the ground of mental illness, but ordered to be detained in strict custody as a mental patient. And then Lord Hoffman refers to the dicta in Clunas, one of which I have shown the court. At letter C, but the majority regarded compensation, even in such a case, as contrary to public policy. Scheller J.A. made the pertinent observation that if the rule didn't apply and the plaintiff had killed the negligent psychiatrist who discharged him, the latter's estate would have been liable to pay the plaintiff compensation for his consequent detention. This case, which Scheller J.A. described as unusual, if not unique, raises an interesting question about the limits of the rule, which it is not necessary to decide for the purposes of this appeal. And we submit what's important about that is that it does not constitute disapproval by Lord Hoffman of the reasoning of the Court of Appeal of New South Wales in Hunter. And indeed, none of their lordships in Gray disapproved of Hunter. At paragraph 51 in the speech of Lord Hoffman, which is at page 1549, he examines the wider version of the rule. And at 4 lines down, after referring to Clunas, he says, first, the rule, the wider rule, as it seems to me, it cannot, as it seems to me, be justified on the grounds of inconsistency in the same way as the narrower rule. Instead, the wider rule has to be justified on the ground that it is offensive to public notions of the fair distribution of resources, that a claimant should be compensated, usually out of public funds, for the consequences of his own criminal act. And lastly, from Gray, a passage from the speech of Lord Roger, which begins at 1550, but I would ask the court to look at paragraph 77 at 1557. Quite a long paragraph, 1557. A long paragraph. I invite the court to read it, but I'm just going to pick up a few lines, beginning, I think, 7 lines down. Lord Roger has been referring to the case of Zastowney from Canada. And just above letter B, he says, in Zastowney and the preceding cases, the need was to ensure that the civil and criminal courts were consistent in their handling of the plaintiff's criminal conduct and its consequences. But that is simply one manifestation of a desirable attribute of any developed legal system. In classical Roman law, the jurists were at pains to ensure that the various civil law and praetorian remedies worked together in harmony in relation to the same facts. One of the hallmarks of a good modern code is that its provision should interrelate and interact so as to achieve a consistent application of its overall policy objectives. And so we see, or we submit, that Lord Roger was there pointing out something which had been touched on by Justice McLachlan in Hall, a seminal case on illegality in Canada, that consistency is not just about consistency between the civil and criminal law, but about consistency between all branches of the law. One then goes to Henderson in the trilogy of cases I'm going to refer to from this jurisdiction, and Henderson begins at page 1681. This, of course, also involved a person who had pleaded guilty to manslaughter by reason of diminished responsibility. And it is, in our submission, important to note what the submissions were and what the issue really was before this court in Henderson in 2020. If one goes to page 1714, just above letter D, we can see that counsel for Ms. Henderson said that although she killed her mother in a savage and brutal attack, she was not in any meaningful sense responsible for her crime. One then goes over the page to page 1716, it's in fact over 2 pages, 1716, we can see that Mr. Bowen for Ms. Henderson submitted just beneath letter C. Further, in any illegality case, there is a threshold question for the court, namely whether the conduct of the claimant is sufficiently turpitudinous to enliven the doctrine. Despite the conviction for manslaughter, on the facts of this case, the claimant's conduct was not sufficiently turpitudinous to enliven the doctrine. It is only if that is not accepted the court should turn to apply the Patel considerations. And then the submissions made on behalf of the defendant, looking again in the report at 1717, at letter G. First there's a reference to Gray, and then at letter H, there was no exception to Gray in respect of persons who did not bear significant personal responsibility, no evidence before the House of Lords as to whether Mr. Gray did or did not bear significant responsibility for his actions, only that he had been convicted of manslaughter. Gray is therefore indistinguishable. The claimant can only succeed if Gray is departed from. So what the claimant was submitting was that the illegality doctrine did not apply despite the criminal conviction. And hence there was a focus upon what she was taken to have accepted by her plea of guilty to manslaughter. And my submission is that the issue in Henderson was in fact a narrow one. Was Gray indistinguishable? Was it binding? It was in that context that there was debate about the question of the claimant's responsibility for her actions. Paragraph 27 in the judgment of the court, which was given by Lord Hamblin, at page 1726, shows the position in relation to a person who has been made the subject of a restriction order by quoting from Lord Justice Musthill in Birch. And I've touched on this already. No longer is the offender simply regarded as a patient whose interests are paramount. No longer is the control of him handed over unconditionally to the hospital authorities. Instead, the interests of public safety are regarded by transferring the responsibility for discharge from the responsible medical officer and the hospital to the Secretary of State and the Mental Health Review Tribunal. So just updating that, it's now, I think, the responsible clinician and the first-tier tribunal mental health, which is a bit of a mouthful, but those are the bodies or the posts which have replaced. But the point is still the same. Paragraph 58 at page 1733. The second subparagraph, all judges considered the relevant policy in connection with the narrow claim was the need to avoid inconsistency so as to maintain the integrity of the legal system, the inconsistency principle. Lord Hoffman didn't consider this applied to the wide claim, but held a related policy did, namely, and he quotes from paragraph 51 of Gray, I understand this to mean that allowing a claimant to be compensated for the consequences of his own criminal conduct risks bringing the law into disrepute and diminishing respect for it. It is an outcome of which public opinion would be likely to disapprove and would thereby undermine public confidence. And he calls that the public confidence principle. So the narrow rule, as identified by Lord Hoffman, has become the consistency principle, and the wide rule has become the public confidence principle. And again, one might pick up here that the narrow rule is described as a need to avoid inconsistency so as to maintain the integrity of, and I would add the words, the whole legal system, whereas the wide rule refers there to criminal conduct. And paragraph 86 on page 1740, Lord Hamblin held that Gray could not be distinguished, involved the same offence, the same sentence, and the reasoning of the majority applied, regardless of the degree of personal responsibility. And that is the ratio, in a sense, of that case. My Lords, paragraph 119 is also important. I would like to mention that in passing, but not to read it out, given the exigencies of time. But paragraph 120, I would like to read at 1746. In considering the issue of consistency and coherence in the law, the closeness of the connection between the claim and the illegal act may well be of relevance. The closer that connection is, the greater and more obvious may be the inconsistency and consequent risk of harm to the integrity of the legal system. So this is all part of consideration of stage A in the Patel test. And then there are a number of pertinent paragraphs beginning at page 1747, between 125 and, in fact, probably down to 131 and 144. But I'm just going to pick up a few.
I suppose it's perhaps worth noting paragraph 119,
yes,
third last line, treats the relevant category as conduct which the law treats as being criminal or otherwise unlawful.
Thank you. Thank you, my Lord. I don't think I can improve on that observation. It's there and it reflects exactly what I am submitting. Paragraph 100. Yes, I think I've read paragraph 120. Paragraph 125, 1747, at letter B. There is a need to avoid inconsistency so as to maintain the integrity of the legal system. Whilst that obviously applies to the narrower rule, it also applies to the wider rule. As Patel makes clear, this is a central and very weighty public policy consideration. And we're still in stage A. I would ask the Court to read paragraphs 126 and 127. 127 is particularly relevant to any submissions that my learned friend Ms. Ayling may wish to make.
And when he's talking about the narrower rule and the wider rule,
yes,
he's talking about the narrower rule is illegality is a bar to loss arising from imprisonment, and the wider rule is wider claim heads of damage. Is that what he's?
That's one way of looking at it. In that summary, the only word I would respectfully cavil at is the use of the word imprisonment.
Right.
Because imprisonment,
detention, then, yes.
I would use the word detention,
Yes.
which is a more neutral word. And what I'm going to be submitting, lady, is that whilst perhaps at one time, certainly in the 1980s when Clunas was decided, it was focused on criminal cases. As the law has developed, and we'll see this from Australia and Canada, detention by a court order, whether or not as a result of commission of a criminal offence, engages the narrow rule. Does that answer, or does that?
But I was asking perhaps a simpler question.
Yes, I apologise.
The narrower and the wider is referring to the heads of loss rather than any aspect of the test.
The test.
Under Patel and Mirza.
Well, could I answer that in this way? The narrower and the wider rule are both principles which are important when one comes to consider stage A of the Patel test. In fact, they are absolutely central in my submission to how one decides the first stage of the Patel test. And what Lord Hamden does in Henderson is he, as it were, updates the language so that instead of calling it the narrow rule, the wider rule.
I'm sorry to interrupt you, but it may be helpful if you go to paragraph 52 on page 1700, you find the definition of what these two rules are.
Thank you, my Lord. Yes. Yes.
Yes, that's what I thought.
Yes.
That's the sense in which you're using them as well.
It is the sense in which I'm using them, with one modification, where it talks about a sentence. I say the narrow rule comes into play not only when there is a sentence of imprisonment, but also where there is detention under sections 37, 41 of the Mental Health Act and under the 1964 Act.
Paragraph 52 doesn't in fact speak about sentence. It talks about loss of liberty, fine or other punishment lawfully imposed. But punishment you take issue with rather than...
I beg your pardon?
It would be the word punishment that you take issue with. Actually.
Yes, I was also reading the word sentence at letter C. Would correct in relation to the sentence imposed by Mr. Gray's case, which would not always be true of a hospital order.
Sorry, yes.
That's what I was trying to address. Insofar as it is said that the narrow rule only applies to the sentence that results from the commission of a criminal offence and the conviction for a criminal offence, we say it travels well beyond that. It travels into the territory of detention, even if you haven't committed a criminal offence, as long as it's done by way of a court order as a result of killing and then being found not guilty of murder by reason of insanity. My lady, I hope I've tried to address my lady's point. I hope I have, and if I haven't, I do have the advantage of having two very high-quality sweepers who will pick up anything I haven't picked up. I was going to show the court 1747, paragraph, I've mentioned paragraph 127, paragraph 128 is also relevant in the context of this case. Paragraph 129, I did want to read. In relation to the underlying purpose of the prohibition transgressed, an important purpose is to deter unlawful killing, thereby providing protection to the public. As far as the public is concerned, there could be no more important right to be protected than the right to life. It is clearly in the public interest that everything possible is done to enhance protection of that fundamental right. There's also a public interest in the public condemnation of unlawful killing and the punishment of those who behave in that way. Then there's a reference to submissions made on behalf of the appellant, and at 131, there is force in these points, but the question should not be considered solely at the granular level of diminished responsibility manslaughter cases. Looking at the matter more broadly, there may well be some deterrent effect in a clear rule that unlawful killing never pays, and any such effect is important given the fundamental importance of the right to life. To have such a rule also supports the public interest in public condemnation and due punishment. And so, translating that into the context of this case and taking as a starting point Lord Hoffman's description of the wide rule, we do submit that it is offensive to public notions of the fair distribution of resources, that this claimant should be compensated for his lawful detention as a result of killing 3 people. And if one looks at it from the perspective of the distribution of resources, if he is compensated, the public will be paying twice. They will be paying for his continued detention in Broadmoor, and they will also be compensating him for that self-same detention. And we do say that the points made there by Lord Hamblin are relevant because one doesn't just look at deterrence at a granular level. There is a value, we submit, in a clear rule that unlawful killing never plays, and in public condemnation of killing. And indeed, that submission is brought into high relief by the respondent's submission here, the suggestion that the killings were not unlawful at all. That, we submit, remarkable submission would mean, if my lords, my ladies adopted it, the message sent out by a judgment adopting that message would be that killing whilst insane is not unlawful. And we don't think at the general level that is the message, with great respect, that should be sent out by any judgment. Turning then to the 3 cases from other jurisdictions, where we see very explicitly the development of the narrow rule, the consistency principle, beyond criminal proceedings, in cases where the plaintiffs were found not guilty of various offences by reason of insanity. Starting with Hall, which doesn't concern such a case, but it's such an important case that I hope the court doesn't mind if I take the court to it. 3621. My lords, I'm very behind my timetable, and if I may just turn to my learned friends. I'm going to have to speed up a little bit. But I'm just wondering whether I can skip Hall. No. Well, I'm not going to skip it, but I'm going to show very briefly one passage in the judgment of Justice McLachlan at 3630. That's where the judgment begins. The crux of the judgment is at page 3637. 3637. At the bottom of the page, Justice McLachlan refers to the extirpi causa principle, and then over the page, having referred to it, in the 5th line, she said this: a more satisfactory explanation for these cases, I would venture, is that to allow recovery in these cases would be to allow recovery for what is illegal. It would put the courts in the position of saying that the same conduct is both legal in the sense of being capable of rectification by the court and illegal. In short, it would introduce an inconsistency in the law. It's particularly important in this context that we bear in mind that law must aspire to be a unified institution, the parts of which, contract, tort, the criminal law, must be in essential harmony. So we take 2 points from this and the remainder of that paragraph. Firstly, Justice McLachlan did not confine relevant illegality to criminal cases. And secondly, she made the point later made by Lord Roger and Grey that the law should be a unified institution in all its branches. Contract, tort, the criminal law, public law, one could add, and so on. Turning then to Hunter, which the report of which begins at 3688. This was a case, the first case that I've shown the court, where the Court of Appeal in New South Wales faced up fair and square to the question of what to do about a person who was acquitted of murder on the grounds of mental illness. We can see that from the first paragraph of the headnote. The Chief Justice Spiegelman, was in the minority. His judgment begins at page 3692. But I'm going to ask the court to look at paragraph 78, which is at page 3704. This debate was all in the context of whether a duty of care was owed, rather than in the context of extirpi causa. But as the Court of Appeal said in this instant case, in this respect, respectfully, correctly, the policy arguments exactly reflect the policy arguments that we are dealing with in extirpi causa cases, or in illegality cases. Paragraph 78. This is the minority judgment of the Chief Justice. The significance of moral culpability in determining the weight to be given to unlawful conduct is clearly established on the authorities. Well, pausing there, we don't accept that. Whereas here, a person has been held not to be criminally responsible for his or her actions on the grounds of insanity, the common law should not deny that person the right to a remedy as a plaintiff. In such a context, the unlawfulness of the conduct is not entitled to weight in a multifactorial analysis. Now, we have two main criticisms of that, in addition to the point about not accepting the accuracy of the first sentence now. Firstly, the Chief Justice did not advert to the impact of the narrow rule or the consistency principle at all in this paragraph. Instead, he appears to have relied primarily on culpability, an approach we submit is wrong. And secondly, he gave little or no weight to the unlawfulness of the conduct. And we say that does not take proper account, doesn't properly reflect the public confidence principle. But somewhat oddly, we would submit, at page 3707, Chief Justice Spiegelman gave a nod, if I could put it in that way, 3707, to the narrow rule, to the consistency principle. Because when he came to assess damages, he didn't agree with the trial judge, paragraph 98. And he referred to a decision, an earlier decision by Justice Adams. And then he said at paragraph 100, His Honour had set out the plaintiff's experience in this regard, including his fear of violence in the remand centre, restrictions on movement and activities involved in being kept in the prison hospital, and restrictions on his liberty. All of these were matters which arose from the lawful conduct of the authorities. In my opinion, the loss or damage he suffered in this regard is too remote from the tortious conduct. Now, he was dealing with remoteness, we submit, partly because he was dealing with the question of a duty of care and not the question of illegality. But that sentence, in my opinion, the loss and damage he suffered in this regard is too remote, is preceded by all these were matters which arose from the lawful conduct of the authorities. And that is a transposition, we say, of the narrow rule or the consistency principle. But more importantly than all that, one then looks at the judgment of the majority, which begins with the judgment of Justice of Appeal Scheller at page 3708. 3708. And the factual analysis here may be important, because what happened was that after the killing, the plaintiff was charged with murder. I'm at paragraph 103. And a special verdict was entered of not guilty on the grounds of mental illness. And he was detained in strict custody in a psychiatric hospital as a forensic patient until released by due process of law, pursuant to Section 39 of the New South Wales Mental Health Criminal Procedure Act. The kernel of his reasoning, we submit, is at page 3766, at paragraph 292. In general terms, two considerations may stand in the way of the plaintiff's success in the present case. Although he was page 3766. In general terms, two considerations may stand in the way of the plaintiff's success in the present case. Although he was acquitted on grounds of mental illness, his act was and remained an unlawful act. He was not his was not justifiable homicide, but an unlawful homicide for which he was not criminally responsible. And then the second consideration we submit comes in the last 6 lines of that same paragraph. Although the plaintiff was acquitted and hence held not criminally responsible for the murder, what followed, for which he now seeks compensation, was the statutory response to the reason for his acquittal, Section 39 of the Mental Health Act. He was accordingly detained in strict custody in a psychiatric hospital, and he claims damages as a consequence of that detention. And at paragraph 298, on page 3768, in the 4th line, but the detention and treatment of the plaintiff was that prescribed by law as a consequence of the unlawful killing, yet the damages here awarded are similar to those which would be awarded as general damages if the plaintiff had been unlawfully detained. And then the judgment, again in the majority, of Justice of Appeal Santow, which begins at page 3771, and at the bottom of 3771, 8 lines up from the bottom of that page, Justice of Appeal Santow referred to a case called Cole and to a statement made by Justice McHugh that some minds may instinctively recoil.
I'm sorry, forgive me, which paragraph?
It's my fault, my lord. Paragraph 312.
12, thank you.
Bottom of page 3771. 8 lines up, and I apologise for I'm trying to avoid reading too much, so I have passed out some of the paragraphs. And if my lord can see the reference to Cole and South Tweed Heads Rugby League Football Club, some minds may instinctively recoil at the idea that a hospital authority and psychiatrist, however careless, may be liable for the loss of liberty lawfully suffered by a forensic patient following his killing of another while insane, itself an unlawful act, but without criminal consequence. Such an instinctive recoil is no substitute for the objective application of tort principle, but that reaction may nonetheless be a reflection of more considered community values, not to be stigmatised as based merely on prejudice or emotion. And at 313, but it does not follow that such a person, as distinct from his victim, should be compensated for the lawful consequences to him that followed the hospital authority's initial failure to detain him for treatment. And at the bottom of 315, I here differ respectfully from Chief Justice Spiegelman's conclusion to the contrary. I do not base my conclusion on any moral culpability on the part of the respondent. Rather, I base it on what I conceive legal policy, ultimately based on community values, would consider just in such a case. And we say that in this judgment, Justice of Appeal Santal is reflecting both the public confidence principle and the consistency principle. Now, oddly, the judgment doesn't appear to have the text of Section 39 of the New South Wales Mental Health Criminal Procedure Act in it. And so more accurately, Mr. Tausig has found the relevant statute, and we see it at 3869, the Mental Health Criminal Procedure Act of 1990 in New South Wales. 3869. And if one goes over the page to 3870, Section 39, subsection 1 says if on the trial of a person charged with an offence, the jury returns a special verdict that the accused person is not guilty by reason of mental illness, the court may order that the person be detained in such place and in such manner as the court thinks fit until released by due process of law. So we submit that the provisions of that section are analogous to the provisions of Section 5 of the Criminal Procedure Insanity Act 1964, which is at page 948. The effect of both of those sections is that in the event of a special verdict, the court has power to order that the person be detained. Here, in England and Wales, under a hospital and restriction order. And as I've said, what follows a Section 41 order is that the responsible clinician, in fact, I'm not sure I have said this, but it's important, the responsible clinician cannot discharge the individual without the consent of the Secretary of State or a decision by the first-tier tribunal of mental health. My understanding is that the tribunal, the mental health tribunal I'm going to call it, is the final arbiter in the event that the individual wishes to be discharged and the Secretary of State doesn't agree. Now,
hospital order discretionary, or is it mandatory?
Well, that's a debate I was just going to come to, because, my lady, there is a debate about that. Can I answer straight away? It doesn't matter. No. There is a debate, largely generated by our case, about whether it is discretionary or mandatory in an insanity case. It may be that Ms. Plowden is right, that in fact it is discretionary in the sense that you still need the opinion of two doctors to enable you to satisfy the terms of sections 37 and 41. But it doesn't matter. It doesn't matter, just as it didn't matter in Hunter, because whether or not the order is discretionary, it is an order made by the court. And so the consistency principle applies if the criminal court, not following a criminal conviction, but it is the criminal court, makes an order the result of which is detention of the claimant. It may be that other members of other appellants' counsel will deal with that. I'm not going to, because it doesn't matter. And lastly, in the trilogy of cases from...
Just to be clear, we're not talking here about somebody who was unfit to plead.
No, we're not.
No. So there's always a possibility that somebody can be insane at the time of the relevant act, yes, but not insane at the time of trial. So the court's bound to have some degree of flexibility.
Yes, quite. And indeed, in the case I'm going to show, Lords, which involved 28 plaintiffs in Canada, some of the plaintiffs were not fit to plead. And the court, we'll see in a moment what the court did about that. But yes, I immediately accept that. That's, of course, right. And I don't propose, especially given the time, to spend a great deal of time on the questions arising around insanity, especially bearing in mind that my Lord Jones was chair of the Law Commission at the time of the 2013 report, I will touch on that, but I was not planning to spend a great deal of time on it. Barker. This is the last of the cases I was going to refer to, and it is to be found, the first of the judgments are to be found at 2842. It's a case from Canada. The first instance judgments were handed down in 2020, and then the Court of Appeal considered the case in 2022. We say it's an important case. It wasn't before the Court of Appeal in this litigation, but we are not going to take the credit for finding it. It was found by Mr. Goodcamp. The first of the judgments begin, as I said, at 2842, and we've put all three judgments in the bundle so that if your lordships want to see my ladyships want to see the factual matrix, for example, in relation to those plaintiffs who are found not guilty by reason of insanity and those who are found not fit to plead, it's there and it's available. And my learned friend, Ms. Plowden, half criticises the case for being very long. I'm going to say something about that in a moment, but because of that, I'm just going to summarise it. It was about a barbaric regime of mental health treatment at the social therapy unit, as it was called, at Oak Ridge Mental Health Centre in Ontario. And I use that word barbaric because it was quoted by the judge and used by a number of witnesses as recorded at first instance. It's an extraordinary regime. It involved, for example, giving patients LSD. It involved strapping patients together, one younger patient with someone who was a member of an organised crime group. It's extraordinary, and it makes for hard reading if it's necessary to read it. There were 28 plaintiffs, and the evidence related to many years of treatment. The trial was separated, as you would expect, into phases. The first stage was liability, second stage quantum, and then there was the appeal to the Court of Appeal. There has, we understand, been an appeal to the Supreme Court of Canada, but that has been an application for leave to appeal to the Supreme Court of Canada. That's been dismissed. 5 of those 28 plaintiffs brought claims for lost earnings during the time that they were detained after being found not guilty of various offences, including murder, by reason of insanity. And it was held that those claims were barred by the ex turpi causa doctrine, as it is called in Canada. Judgment at first instance on damages appears at 3166. And it's entitled Judgment Damages, a decision of Justice Morgan. The reasoning on the question of ex turpi causa, as it's called there, begins at 3188. Page 3188. It begins at paragraph 94, the reasoning. I'm going to take the court, if I may, to paragraphs 101 to 102 to see how the case was put by the Doctors' Council. The plaintiffs sued not just the government body responsible, but also the individual doctors. And at paragraph 101, on page 3190, the Doctors' Council relied on Grey and Thames trains. And at paragraph 102, counsel for the plaintiffs, the patients, took issue with the reliance on British case law, since in cases such as Gray, the accused was found guilty in a criminal court before being institutionalised due to his diminished responsibility. It is their view that the ex turpi causa rule only prevents compensation being paid for time lost while serving a prison sentence pursuant to a criminal conviction, and does not apply to time spent institutionalised in a mental hospital without having been convicted of an offence. Just pausing there, almost exactly the submission that's being made here by the respondent. 103, plaintiffs' counsel submit that since the finding of NCR, which we think means not criminally responsible, so a more modern, in Canada, a more modern definition, or the old not guilty by reason of insanity, does not connote a criminal conviction, there is no inconsistency in the law involved in compensating a person for institutionalised time, including in a maximum security hospital. They say, along with Lord Bingham in Gray at para 15, the hospital order should not be treated as being consequence of the defendant's mental condition. My ladies, my lord, that's probably a mistake, because Lord Bingham doesn't give a judgment in Gray. I think that must refer to Lord Phillips. And paragraph 104, in other words, plaintiffs' counsel argues the ex turpi rule prevents a person from being declared guilty and collecting compensation for the same act, but it doesn't prevent a person from being institutionalised and collecting compensation for the non-culpable act that led to his admission to the institution. Counsel for the defendants, by contrast, do not see the criminal verdict as being the point of inconsistency with the damages claim. Rather, they see the discretion of the review board in holding or releasing the plaintiffs to be the point of inconsistency with the damages claim. And then there's a reference to Zastouni, and at paragraph 107, Justice Morgan said this, wrote this: without the ex turpi causa principle being applied to such cases, there would be an avoidable inconsistency in the law. The civil court would either be second-guessing the review board, as Justice Rothstein suggested, that's in Zastouni, or it would be sitting in judgment of the review board's decision to maintain the plaintiff in an institutional setting, when that decision is within the review board's sole discretion. And that would be giving with one hand and taking away with the other. Now, in the instant case, the respondent did not challenge the disposal made by Mrs. Justice Gray at the criminal trial. Mrs. Justice May. Is that wrong? Yes, I didn't say May. I meant to say May. I'm told I should have said May. I apologise. Hasn't challenged that disposal, which placed him under the jurisdiction of the first-tier tribunal for mental health, in a way we submit analogous to the Ontario Review Board. And we see how that point went on appeal in the judgment of the Court of Appeal, which begins at 3330. Judgment begins there, but I wonder if the court could turn, please, to page 3438, where we can see that the Court of Appeal considered the ex turpi causa arguments. If one goes to 299 on page 3439, on their cross appeal, there were appeals on various points, but this is the one that matters for the purpose of this discussion. The respondents submit the ex turpi causa doctrine does not apply absent guilt or moral responsibility for wrongful conduct. So the respondents were the plaintiffs, the five plaintiffs. And one then sees at paragraph 303 the Court of Appeal's decision on this, having referred to Zastouni at 303. That's at page 3442. At 304, first, it is clear from the foregoing that the doctrine is not restricted to cases of criminal conduct, but applies as well to wrongful conduct. That's down here at paragraph 20. The appellants argue that the conduct leading to the respondent's institutionalisation was wrongful. They note the respondents committed the actus reus of the offences, even if they were not found to have the requisite mens rea. On this basis, we accept that there's no principled reason why the doctrine shouldn't apply. Second, the application of the ex topi causa doctrine is justified to preserve the integrity of the legal system. Allowing the income loss claims for extra time spent in a custodial institution would be inconsistent with the Ontario Review Board's exclusive jurisdiction over the respondents and would run the risk of creating an inconsistency in the law. And then this, perhaps the most important sentence of all the cases I've read, the fact that the ORB detention is non-punitive is irrelevant. The fact that this respondent is detained subject to the decisions of the Secretary of State and the mental and the first-tier tribunal is irrelevant. So we say that that judgment espouses at least the consistency principle, and we adopt the reasoning. And we can see from paragraph 309, which I'm not going to take the court to, that the appeal on this issue was dismissed. Now, we submit that this case of Barker, constitutes a formidable hurdle for this respondent. In the respondent's case, the decision is impugned, as it really has to be, on three grounds. First, and I touched on this earlier, it is said that the illegality point was a relatively minor point in a long judgment. Well, we submit the length of the judgments does not diminish the quality of the reasoning on illegality. Secondly, it is said that the decisions in Clunis, Gray and Henderson were not before the Court of Appeal of Ontario. We don't think that can be right because, as I showed the court, Justice Morgan explicitly referred to Gray and quoted it. He referred to Lord Bingham rather than Lord Phillips, but he explicitly referred to Gray. And, of course, Gray refers to Clunis and Henderson follows Gray. Thirdly, it is said in the respondent's case that the Court of Appeal of Ontario was wrong to describe the plaintiff's conduct as wrongful. Well, I've no solution to that. We submit that killing 3 people was wrongful, even if the respondent was insane. And we refer to what Lord Neuberger said. It would, in this context, be odd if what was described as wrongful in Canada and Australia was not also wrongful here. So we submit that on authority, the consistency principle and the public confidence principle support the application of the illegality doctrine. I'm then going to turn to stage B of the Patel trio of considerations, and I'm going to take this as fast as I reasonably can. A number of policy reasons supporting the denial of the illegality defence are relied upon by the respondent. Firstly, that courts should adjudicate civil wrongs. Well, we do say that we're not stopping adjudication here. We're trying to stop certain heads of damage which fly in the face of the illegality doctrine. But even if your lordships decided this case on the basis that the heads of loss could not be proceeded with, the claimant, the respondent, still has his claim under the Human Rights Act, albeit that there are different considerations under the Human Rights Act. But the factual basis for the claim under the Human Rights Act is identical, and we see that from paragraph 109b on page 507. We also rely on what Lord Hamblin said about this point, determination of civil wrong.
What was that page number?
Well, my lady, I'm happy to take...
No, just tell me what the page...
It was page 507, and now I have a doubt whether that's the correct page. So
I just didn't hear what you said.
I apologise, my lady.
What is it?
It's part of the particulars. I'm going to take the court to
it. It starts at 506, Article 8 of the Convention.
Thank you, my lord. If one goes to page 506, this is part of the pleading. That is to say, the particulars of claim. And I was going to refer to B on page 507. There were repeated failures by the authorities to take adequate steps to ensure the claimant's health and well-being whilst in detention upon release from custody on the 9th and 10th of February, and each of the common law breaches of duty set at above is also a breach of Articles 3 and 8. So, factually, albeit that with respect, the hurdle for proving an Article 3 claim is high, factually, the same allegations are relied upon. So we submit that the court should focus, indeed, in other cases it will not be so that an Article 8 or Article 3 claim is brought. So we do submit that the court should respectfully give a judgment on the common law position. We submit that the claimant will be able to pursue his claim in any event under the Convention, but also there is an inquest, and the inquest has powers which civil courts do not have, in particular powers to make recommendations and powers to require certain public authorities to respond to those recommendations. Staying with B in the Patel defence, it is said that the defence of illegality will disproportionately affect the most severely mentally ill. Well, we submit that if we are right about the need to preserve coherence in the law, that trumps the rights of the parties, to use Justice McLachlan's words in Hall. Lastly, and I haven't dealt with them all because of the time, but debarring the claim, it is said, would debar a claim for the very thing which the appellants were under a duty to prevent. Well, first, the claim won't be debarred. Certain heads of loss in the tort of negligence will. And secondly, the doctrine of the very thing which the appellants are under a duty to prevent is an elusive one. The problem is identifying the very thing which the defendants were under a duty to prevent. Had, for example, you asked the forensic medical examiner why he was performing the assessment, he probably would not have said to prevent the claimant from being released and killing people. He's more likely to have talked about the risk of harm both to the claimant or respondent himself and to the risk of harm to others, but not the risk of killing. Then, stage C, we pick up 3 points on proportionality. We do not accept, so far as G4S is concerned, that there was a very high order of negligent conduct here, even on the pleaded case. There were 2 impugned assessments by a healthcare professional on the 9th of February 2019, which suggested the respondent was fit to be detained and interviewed. There was an assessment by a doctor on the 9th of February, a forensic medical examiner. He concluded that a mental health assessment was not required, but that the respondent, the claimant, should be seen the next morning by the Trust's staff. It is not alleged, and it may be that when the President described this as being a very high order of negligent conduct, it may be that this hadn't been picked up. It is not alleged that either of those G4S staff were told about telephone calls that are said to have been made by the respondent's mother to the police. And the police are the one authority which has in fact not joined in to this application to strike out. So even assuming that they were negligent, we submit this is not negligence of a gross kind, but at its highest, a failure by staff to assess a psychiatric condition accurately and do more for the detainee during a relatively brief period of detention on the 9th of February 2019. Now, we of course accept excuse me, we of course accept that the respondent's insanity has to come into the balance on proportionality, but so too should the seriousness of the killing and the centrality of the killings to the claim. I turn now to the last of my rubrics, last heading, the Court of Appeal's decision. We've submitted in our case that on the basis of the decision of the Court of Appeal, a lot hangs on the distinction between the criminal law defence of diminished responsibility and the defence of insanity. We would invite that our submissions there are between paragraphs 21 and 32. I'm just going to mention 2 points. One undesirable consequence of the Court of Appeal's decision is that it will provide encouragement to defendants to criminal charges involving homicide to plead not guilty by reason of insanity, so that they can then potentially bring claims which will not be claims for heads of loss, which will not be barred by illegality. And it's plain from the judgments of the experienced members of the Court of Appeal that pleas of diminished responsibility, and my Lord Lloyd Jones will have knowledge well beyond what I'm about to say, that pleas of diminished responsibility and insanity are notoriously influenced by forensic choices based upon the likely outcome for the defendant at the criminal trial. And we do say that the decision of the Court of Appeal encourages, if it is correct, a plea of insanity. And we think, though the numbers are small, there may be an increase in the already significant burden on the criminal courts. We also submit that it will be in the interests of a claimant in later civil proceedings to challenge any findings of manslaughter based on diminished responsibility, so as to contend that actually the claimant was insane, thereby enabling him to bring a claim.
Would it be open to a civil court to challenge the jury's verdict?
Well, that is
behind it in that?
that is a matter for argument. No doubt, instructed by other parties, I would be told to say it isn't. But as a matter of law, it is open where the parties are different.
Well, it may not be an issue of swap.
No.
But it's a remarkable thing, isn't it, to go behind
it is a remarkable thing.
To seek to.
It is a remarkable thing. I immediately accept that. But I would say 2 points. First, it has already happened.
It might be hunter abuse.
It might come within the remit of a hunter abuse. I immediately accept there are arguments about that. I'm going to say 2 things, if I may. First of all, it has actually happened in a case that a person who pleaded not guilty by reason of guilty by reason of to manslaughter by reason of diminished responsibility has challenged that and said, no, actually I was insane. And the case is Brown. It didn't result in a determination, but you'll find the papers on that case at pages 889, 895 and 900.
Sorry, 889?
889,
yeah.
895 and 900. But it was also done in an American case in 2022 in Miller and Patel, which the report of which is at 3837 to 3847. Now, I immediately accept my Lord Jones's point that it may be difficult, it may be a hunter abuse, but it is not a submission that can be simply ruled out, certainly without exploration of the authorities. We've also submitted, moving on to another point, that the Court of Appeal was wrong to focus on culpability in the way that it did, and we've set that out at paragraphs 59 to 64. But perhaps at the forefront of our submissions about the Court of Appeal is that the Court of Appeal wrongly characterised the narrow rule or the consistency principle. And if my lords, my ladies, goes to the judgment of the Court of Appeal, I think this is the only time I'm going to refer to documents, apart from the particulars of claim, in the first bundle. Page 300, paragraph 98. The appellants also, I'm in the majority judgment, Lord Justice Underhill. The appellants also emphasised the point made by the majority and President that it was inconsistent for the claimant to claim damages for detention pursuant to an order lawfully made by the court. I do not see this as a distinct consideration. If the detention has no punitive element, which in the case of a verdict of not guilty by reason of insanity it does not, its lawfulness is an irrelevance. If, say, a patient had been negligently prescribed a drug which caused a psychotic state and had to be sectioned, it would be no answer to a claim against the prescriber for damages for the loss of liberty and distress caused by their detention to say that the detention was lawful. My lords, my ladies, there is a critical difference between sectioning, which is generally done under sections 2 and 3 of the Mental Health Act, and is done on the recommendations of 2 medical practitioners, and an order made by the court. Sectioning does not involve any order made by the court. It is carried out, as I say, under the Mental Health Act, on the recommendation of doctors. So that we respectfully submit, leaving aside that it doesn't refer to Barker, and there can be no criticism for that, but it doesn't. It doesn't also grapple with the fact that what matters is that there was a court order here under sections 37 and 41, and no damages can result from the lawful detention of this respondent in accordance with the consistency principle. My lords, my ladies, I have gone well over my time allotment. I'm very grateful to my learned friends for giving me a little bit of extra time. I'm very happy to try to take questions, but I'm also nervous about how things will go with the other Appellants Council after this.
No, I don't think we have any questions for you at the moment. Thank you, Mr. Moon. Ms. Ayling, if you're able to point 2 microphones towards yourself, you'll be picked up better by our live stream.
I think I'm going to be given some assistance. Yep, thank you. My lords and ladies, I just wish to start by checking one practical point, which is this, that we have 3 counsels speaking for the Trust. I take it that's not objected to by the claimant. No, I'll proceed then. Thank you. I do wish to repeat in open court, as I begin, what we said in the Trust written case, which is that we recognise the gravity of these attacks and their effect on the surviving victims, because there are 2, and also on the family and friends of the victims who did not survive. And I know the claimant's family are here in court. So we do have the greatest possible sympathy, and it is against that background that I make these submissions. So I intend... I think we're just going to rearrange so that I have...
Yes, just take a moment. We're not so rushed that we can't allow a moment or 2.
No, it's fine. Is that okay? Yeah, it is.
We'll have a lecture.
No, I think that's okay.
Sure?
Yep. Okay. Right, so we've rearranged so I intend to deal briefly with the facts and the statutory mechanics and with the relevant statutory provisions. So I'm, in a sense, turning the case on its head. I'm going to look at why the Act was unlawful and what led to the claimant's detention. I'm going to look very briefly at the current law on the illegality defence, very briefly indeed, given the submissions of Mr. Moon, with whether there's a threshold for consideration of the illegality defence, and if the Trust is right and the other appellants are right that there is a threshold, whether it's crossed. I'll deal very briefly with Hunter to make a single comment about unlawful conduct, and briefly with the other overseas cases, and then deal with the application of Patel and Mirza, and make some brief reference to the GBH charge, the Section 18 wounding charge, which has not been dealt with so far, but which we say is relevant. And then Mr. Gukamp will deal with the academic literature, and Mr. Ruck-Keene will deal with the convention point. And we should be able, I think, to keep to time. So let me turn to the facts then. So the claimant attacked Mr. Ellis on the 9th of February after the first arrest and release. And of course, you have an agreed chronology from us in the papers. He was arrested and released, and then he killed Mr. Payne and the two Carter brothers, and he attacked, there was a Section 18 charge for this also, Mr. Bellavicius after the second arrest and release. So there were two charges of wounding with intent, contrary to Section 18 of the Offences Against the Person Act 1861, but those were left to lie because it was the murder charges that were proceeded with. And I won't take you to the reference, but it's at page 675. There's an exchange between Mrs. Justice May and Mr. Smith, Queen's Counsel, the prosecution. The jury heard, as you know, from 3 psychiatrists. On each count, they found the claimant not guilty by reason of insanity. That is at page 672. And as Mr. Moon has said, the order authorising the claimant's detention was then made under Section 5 of the Criminal Procedure Insanity Act 1964 as amended, and it was a decision by the state to detain him in the interests of the public. And I'm just going to unpick that in what follows. So the special verdict under Section 2 of the Trial of Lunatics Act 1883 is amended. The Act is at page 1027 of your bundles. And as amended, you will see that Section 1 deals with acquittal on the grounds of insanity. Section 4 is the finding of unfitness to plead, and I do pause there to say, it's Section 4A that in fact I want to look at. If there is a determination...
Give us a page number again.
Sorry, page 947.
Page 1027 is just Section 2.
I'm sorry, I've taken you to the wrong provision. It's page 946, I do apologise.
946.
Yeah. So 946 is the Criminal Procedure Insanity Act. I do, in fact, want to look, I apologise, I'm tangling myself, to look at Section 2 of the Trial of Lunatics Act, and that is at page 1027. Yeah, I'm sorry.
Yeah.
Yeah.
Please don't feel unduly rushed. At the end of the day, it's better to take more time and for us to absorb it than to go so quickly that we can't absorb it.
Yeah, that's very helpful. Thank you, Marlene.
So was the whole of Section 2 then, is that mostly as in the 1883 Act, but the last phrase is what was substituted by the 1964 Act, is that right?
Yes, I think that's right, my lady, that it's the accused is now not guilty by reason of insanity. But the passage or the statutory wording that I wish to look at is that where in any indictment or information any act or omission is charged against any person as an offence, and it's given in evidence on the trial of such person for that offence that he was insane so as not to be responsible according to the law for his actions at the time when the act was done or omission made, and this is the crucial part, then if it appears to the jury before whom such person is tried that he did the act or made the omission charged. So that is where the special verdict hangs, and that, we say, is the actus reus of the criminal offence. So if I take you to the first authority I wish to look at, which is Attorney General's reference number 3 of 1998, which is at page 1144. You will see from the head note that when determining, well, let me just leave you to look at that for yourselves. It's looking at what is needed to be proved in determining whether the defendant did the act or made the omission charged. And if I take you then to page 1152 in the Court of Appeal's judgment, just above, between E and F, the paragraph "for the sake of completeness," we note that the same words "did the act or made the omission charged" appear in section 62 of the Mental Health Act 1959, now section 37(3) of the Mental Health Act. And what is then said is that the pattern is entirely consistent with an overall framework designed to ensure, first, that those who are legally insane should not be deprived of their liberty or, but by nowadays, made subject to orders of the courts exercising criminal jurisdiction unless they've behaved in a way which constitute the actus reus of a criminal offence, and second, if they have to protect the public under a wide range of powers in which the focus is treatment, sometimes in the community, sometimes where necessary in the interests of public safety. And turning over the page, then to page 1153, the Court of Appeal says, this is the passage at the bottom of that page, between F and G, accordingly, the judge's reasoning in the present case was wrong. Despite the potential difficulties illustrated by counsel in their arguments, the advantages of certainty and the impossibility of providing a definitive answer, I jump over the next couple of words. In our judgment, the criminal law should distinguish between providing for the safety of the public from those who are proved to have acted in a way which, but for their mental disability, would have made them liable to be convicted and sentenced as criminals, and those whose minds, however disturbed, have done nothing wrong. So far as the criminal courts are concerned, we don't accept that public safety considerations can properly be deployed to justify the making of orders against those who have done nothing which can fairly be stigmatised as a criminal act. So it is the criminal act that is important. And if you look then, a number of examples are given which we submit are helpful in looking at what the actus reus, done the act or omission charged, and actus reus are. Our concerns can be readily illustrated by practical examples. A person with mental disability swimming in an overcrowded public pool should not be at risk of the consequences of a finding of insanity when the alleged incident, indecent touching of another swimmer, may well have been accidental or non-deliberate. So that's the hierarchy of criminal defences. I didn't do anything deliberate. On the other hand, where an apparently deliberate touching takes place, in what are the face of it are circumstances of indecency, the individual in question should not avoid the appropriate verdict on the basis of his own mistaken perception or lack of understanding, or any defences arising from his own state of mind. The difficulties are, if anything, greater where the alleged crime is more serious, and the Court of Appeal looks at the question of rape, where sexual intercourse has taken place without the consent of the woman, and the defendant has established insanity. He should not be entitled to an acquittal on the basis that he mistakenly but insanely understood or believed that she was consenting. So the criminal act, the rape, remains the same from the woman's point of view. There is a criminal act of rape. The insanity defence does not affect that. And the third example, when an individual surrounded by a group of much larger, aggressive and armed youth strikes out and lands a blow on one of them who were unfortunately forced to the ground, sustaining a fatal head injury, it would be unjust if we were prevented from inviting the jury to consider that his violence might have been lawful. If you look at the end of that same paragraph, excluding this individual's own damaged mental faculty at the time, the jury might conclude that although he caused death, his actions were not unlawful and so did not constitute the actus reus of murder or manslaughter. So we draw from that, as I say, that the criminal act remains the same, even if the not guilty by reason of insanity verdict applies, and it is an unlawful act.
So in the example of the individual surrounded by the youths, he might be entitled to a defence of self-defence, which would be an absolute defence.
Yes, exactly.
And he's not disentitled to that because of his mental health?
So the first question is, was there an actus reus? And the second one, and this is important when we look at the academic taxonomy, and that's why we rely on it, it's not an empty philosophical debate, is that the first question is then, do you have a full defence, such as self-defence?
Yes, there's usually, I don't know what the current procedure is in England and Wales, but in other jurisdictions, certainly, if there's a plea of insanity, there will nevertheless be a hearing to determine whether the actus reus was committed by the defendant.
Yeah, indeed. And that is the position if there is an unfit to plead position as well, if you look at the Act.
And that wouldn't have to be in England and Wales, because you can't plead guilty by reason of insanity.
No, it has to
have to have a trial of that issue.
It can't be accepted, unlike manslaughter by diminished responsibility. Yeah.
But this passage would suggest that the court, acting under Section 2, has to go rather further than that and has to consider the possibility of a defence.
Well, if it's raised, which it certainly wasn't in this case, but if it were raised, then that has to be considered. First of all, yes, that's the position as I understand it. I was going to take you next to the authority of Antoine, which you've also got, which makes good this point and indeed approves the Attorney General's reference that I've just looked at now. So Antoine is in the supplementary bundle supplied by the claimant, which I hope you also have. And it's at page 49 of that supplementary bundle.
Was that on the 10th of July?
Oh, yes. This is a bundle called Hyperlinked Bundle of Respondents' Case.
That's the one. Yes, that's
it's 172 pages.
Yep.
Yes. That's the one, yes. So,
sorry, which page do you want us to go to?
It's page 49 of this hyperlink bundle. I suggest that I do ask you to read the head note at page 49 and on to page 50. Now destroy the microphone. So at page 75, there's a long extra, the Court of Appeals judgment is set out here, but if you turn to page 75, you will see there that two questions were certified for the House. The first was, where pursuant to section 4A2 of the Criminal Procedure Insanity Act 1964, a jury has to determine whether an accused person has done the act of murder, is it open to the accused to rely on section 2 of the Homicide Act? And then there was also a wider question, where pursuant to section 4A2 of the Criminal Procedure Insanity Act 1964, a jury has to determine whether an accused did the act or made the omission charged against him as the offence. Must the jury be satisfied more than the actus reus of the offence? Must the jury be satisfied of mens rea? And the first point I draw from this is if you turn to page 79, Lord Hutton deals with, at the top of that page, Attorney General's reference number 3 of 1998, and he sets out what that case looks at. And at paragraph, if you turn then through to page 81, he says the judgment in R against Egan is inconsistent with the decision in Attorney General's reference number 3 of 1998, and in my opinion, the latter decision is correct. So that's the decision we've just looked at, defining what one has
I'm
to
sorry,
do.
you're reading from page 81.
Page 81, I'm sorry, I am taking this.
It's just
as
above G.
Give us the letter, this letter F.
It's
on
just
page
above
81.
G.
Got it, thanks.
Yep. So affirming that the decision in Attorney General's reference number 3 of 1998, which we've just looked at, is correct and should be followed. And he looks also in this judgment at the effect of section 4A of the Criminal Procedure Act, which is the provision dealing with unfitness to plead, but which also looks at the act or omission charged wording.
But what he was unfit to plead was diminished responsibility.
Well, the question was whether it was open to him to argue that he had diminished responsibility, having been unfit to plead on a murder charge. And the answer was, my lady, that it wasn't open to him to argue that. But if you look at the passage at the bottom of 84, between G and H, Lord Hutton sets out what the purpose of section 4A is, and in my submission, all of that applies to the act or omission charge provision that we've looked at in section 1 of the Trial of Lunatics Act. I'll leave you to read that for yourselves, but it's to strike a balance between the need to protect a defendant who has in fact done nothing wrong and the need to protect the public from a defendant who's committed an injurious act which would constitute a crime if done with the requisite mens rea. Yes. So if the defendant has committed no criminal act, that is the first line of defence. If he has in fact committed a criminal act, then the unfitness to plead provisions come in, and the associated powers of detention under the Mental Health Act, which I'll turn to next.
And the commission of the act charge would have to be proved beyond reasonable doubt, yes, to the satisfaction of the jury.
Exactly, yes. Yeah. And if you look, the point about self-defence being the first line of defence before one comes on to insanity is further made good at the bottom of page 85. If you look at F, in their full and helpful submissions, Council raised a further issue on which they invited guidance of your lordships. The issue is this, and I ask you to read that. It's whether a defence of accident or mistake or self-defence could have been raised if he'd not been under a disability and the trial had proceeded in the normal way. And at the bottom of that page at H, Lord Hutton says, I would hold that it should be resolved in this way. If there is objective evidence which raises the issue of mistake or accident or self-defence, the jury shouldn't find the defendant did the act unless it is satisfied beyond reasonable doubt on all the evidence that the prosecution has negatived that defence.
Because those defences would go to the question of whether the actus reus had been committed.
Exactly.
Whereas the diminished responsibility defence goes to the mens rea.
Well, we would say, in fact, it doesn't. I'll turn to Loke this afternoon after the lunchtime adjournment. You can have mens rea and still have the not guilty by reason of insanity verdict, but it does go to criminal responsibility.
These are protections for the defendant.
They are.
But it's all directed at the actus reus of the offence. So if the burden is discharged, what is established is not a criminal offence, yes, but the actus reus of a criminal offence.
Exactly. But if
how does that help you?
Because if you are not guilty by reason of insanity, that verdict is only open to you if it's already been found that you've committed the criminal offence, or the actus reus of the criminal offence.
That's the distinction I'm drawing.
Oh, I've misunderstood you.
It's only open, that verdict is only open, if it's proved that the actus reus of a criminal offence has been committed.
Yes.
It doesn't prove that a criminal offence has been committed.
Well, it proves that the actus reus has been committed,
Yes.
and then the effect of the not guilty by reason of insanity verdict comes in after that, and there is no criminal responsibility.
But as I understand it, you're praying this in aid in support of the submission that the conduct is unlawful.
I am. Because on the basis that the actus reus, there's residual unlawfulness, which means the actus reus itself is unlawful. I accept that it's shorn of criminal responsibility.
Falls short of establishing that it's criminal. Yes.
Yes, I do accept that, yes. I have to.
Thank you.
Another way of looking at it would be to ask whether the killing is lawful. And it clearly isn't a lawful killing. And is there some intermediate position between them? A killing which is neither I suppose it has to be the respondent's position, that there are killings which are neither lawful nor unlawful.
Well, that is now, for the first time, as I understand it, the position in the claimant's written case that Lord Justice Underhill used the language of unlawful act throughout his judgment, and indeed the President and Lady Justice Andrews both accepted that there was an unlawful act. I understand Mr. Justice Garnham to have accepted exactly the same thing, but the claimant now says in their written case that unlawful isn't the word that should be used. It appears that there is, on their submission, some interstitial or innominate category, which is simply a killing, which is neither lawful nor unlawful, and we say that is not a possible outcome. There is either unlawful killing or there is lawful killing, and these three killings were not lawful killings.
But do you say that a killing in self-defence is a lawful killing?
I would say that, yes.
And would you say that an accidental killing is a lawful killing?
I would say that, yes.
Yes.
Certainly, the focus here is on crime, because the killing is unlawful in the sense that it's tortious.
Well, it is tortious, and we have those authorities in the bundle before you, but from the point of view of those who were attacked, and that's why I took you to the examples in the Attorney General's reference, there has been a rape. It is that the rapist did not understand when he committed it that what he was doing was wrong, either morally or legally. But the unlawful act remains in my submission, and I understand that of the other appellants. It is shorn of criminal responsibility. The claimant is shorn of criminal responsibility because of the not guilty by reason of insanity verdict. And so that is important to our analysis of the way the insanity defence works. There's a hierarchy, and mistake, accident, self-defence come above not guilty by reason of insanity. And Mr. Goodcamp will take you through the academic literature this afternoon, but it is best not to kill at all. That's the beginning point. Self-defence then comes before insanity, and then insanity comes in at the last stage down the line. It's an irresponsibility defence, as Mr. Goodcamp will explain to you. And just to make good that point before the lunchtime adjournment, in Henderson, at paragraph 22, Lord Hamblin cited Gold, and I'll just give you the page number, I won't take you there, it's page 1725. He says that by definition, before any question of diminished responsibility, the homicide must have been done with murderous intent to kill or to do GBH and without either provocation or self-defence. And I submit that obtains in exactly the same way when we're talking about insanity. It's provocation and self-defence come first. My Lords, what I was going to do was take you next very briefly to Loke, which I can probably do in the last 2 minutes remaining before 1 o'clock, and then after lunch I would like to look at the provisions under which Mr. Lewis-Ranwell is actually held, how Section 37, 41 and 45A work under the Mental Health Act. So Loke is in your bundle at page 1900. The defendant was charged with harassment under the Protection from Harassment Act 1997. And the question was the defence of insanity available to the defendant, given that the mens rea required for the statutory tort of harassment is objective? And Antoine is cited to the court. And Paras, I ask you to read the head note firstly at page 1900, but then for your note, and in the interest of time, I won't take you to it. Paras 39, 40, 41 and 48. A defendant may have the mens rea for the offence, but nonetheless receive the benefit of the special verdict. And that is because you can understand that you are killing, but not understand that what you are doing is morally or legally wrong. The conclusion is at para 55.
Age?
Just 1914.
In the present case, the expert evidence of the psychiatrists at the criminal proceedings, as I understand it, went to the issue as to not as to whether he understood the nature and quality of his acts, but whether he appreciated it was wrong.
Yes. So
this would be a case where the mens rea might have been established.
Yes, we submit that it was established. I've covered that in detail in our written case. So he understood that he was killing. He understood the nature of his act. He's McNaughton 2, not McNaughton 1. Yes. We haven't looked at McNaughton, but he didn't understand that what he was doing was morally or legally wrong. So he did, in our submission, have mens rea, in fact. But the not guilty by reason of insanity verdict steps in at that point. Yeah, he did the actus reus, had mens rea, but was entitled to the not guilty by reason of insanity verdict because he didn't have criminal responsibility. So that's probably a convenient moment, lords and ladies, and I will deal after lunch then with, as I say, with the detention provision.
Thank you very much. We'll resume then at 2 o'clock.